A warm welcome to all participants who have joined us today for this masterclass. SCAI is dedicated to fostering the growth of the shopping center industry in India. One of our key objectives is to facilitate knowledge sharing among industry professionals. Our mission is to keep industry experts informed about the best practices adopted by successful shopping centers worldwide. Each month, we host a webinar or masterclass to help industry professionals enhance their operational skills. We invite seasoned professionals to share their experiences and insights. The subject of today's masterclass is Understanding Tenant Agreements and Legal Compliance. Mr. Vijay Gupta is conducting today's session. Vijay is a seasoned legal professional with over 25 years of experience, having held leadership positions in legal, secretarial, and compliance across the real estate, commercial leasing, retail, hospitality, and IT industries. He is currently associated with Nexus Select as a General Counsel, Company Secretary, and Compliance Officer. Prior to this, he had a long tenure with K. Raheja Corp Group, where he was actively involved in their retail, real estate, commercial leasing, and hospitality verticals. During his time, he played a key role in the launch of 5 new malls, multiple acquisitions, and asset monetization. He has also worked with CMS Computers Limited, where he was instrumental in restructuring of the group and securing private equity investment. This is all about Vijay. Viewers, if anything comes to your mind regarding the subject, you are welcome to post your questions, which we will address them at the end of the session or during the break of the session. So over to Vijay. Vijay, all yours. Once again, we welcome you.
Thank you.
Thank you.
So, thanks, Sanjeev. That was a really sweet and nice introduction. So, thank you once again, and also for setting the tone of the webinar. So, really a nice start. So, dear friends, thank you. So, dear friends, thanks for being a part of this webinar, and I am really honored to be invited by SCAI and being a part of this webinar and part of knowledge sharing as an industry associate. So thanks once again. So I'll try to do justice to the subject, share some knowledge and see, and of course at the end of the session we'll have a question answer session wherein I'll try to answer some of your questions to the best of my capacity. So before I start, a few disclaimers. The views expressed in this webinar are my personal views. These are not the views of my organization or do not kind of indicate that this is the philosophy which is followed by my organization. Secondly, this is a discussion. I am not giving a legal advice in any manner. So when you are working on your matters, please do feel free, please do take legal advice and then act on the same matters. So as Anjeev pointed out, we are running this session on the tenancy agreements. So when you look at this subject, it's a very wide subject. So as to ensure that this I can deal with in sections, I have put this in 3 sections. One, I will start with explaining the laws behind the subject, followed by the draft agreements which are prepared by all of you and the standard terms, a discussion on the same, and lastly dealing with the issue of termination, expiries, and the so and so. So I'll start by sharing my screen, which is the presentation, which will which I'll run through.
Vijay, can we take questions in during the break also?
Yeah, would be happy to. In fact, to make it more interactive, would be we can do something like if you feel that there are sufficient questions in between as well, you can stop me. We can take the Q&A and then proceed. So,
or maybe after the break of session, we can address those questions.
Sure. That would be really great. So that would help in making an introduction and help in making the webinar interactive and maintaining the interest of people. Yeah.
Well, once again, I request all my viewers, we have got a good viewership today, that anything comes to your mind, definitely you can post them, and maybe we may take up your question in the second break. Okay, sir. So all yours, and please go ahead, sir. Thanks.
Sanjeev, thanks once again. So as I start, when you look at tenancy agreements, so they can be divided into three types. One, a lease agreement, which is a contractual document which is done between parties, and the parties are bound by the same. A leave-in license, which is a limited right, and again a contractual agreement. Last is a tenancy, which is kind of a creation of law. It could be in the nature of a tenancy at will, where the parties have not contracted. Rather, it's more of a arrangement wherein the lessor allows the lessee to continue without a document. It would be something like a monthly tenancy, which thereafter continues. Next is a tenancy by sufferance, which is basically a holding over. So at the expiry of the lease agreement, if the lessee continues, it would amount to a tenancy by sufferance. And last is a statutory tenancy, which is nothing but a tenancy which is recognized by law and something which would be governed by the Rent Control Act. So I've put the definition of a lease in front of you. I don't intend to kind of recite it. So to tell you in short, it's basically a transfer of right to enjoy immovable property made for a certain term for a consideration which is given from the lessee to the lessor for a definite period, and a arrangement which is accepted by the lessee. So in case you look at this this definition in so in case you look at the essential elements, you'll see that there are few essential parts of this definition. One, there are two parties to agreement, so there would definitely be a requirement that there are two parties which are competent to contract and who want to associate to take a lease. Next is a subject matter of a property which has to be there for constituting a lease. Next, a transfer of a right to enjoy, followed by there has to be a defined term which is either it's either a defined term or it could be in perpetuity. There has to be a lawful consideration, and there has to be an acceptance of the transfer by the transferee. Now, if you look at this in detail, there are few things which come out, or which are not really covered in this, but because this is a transfer of an interest under the Transfer of Property Act, the provisions of the Transfer of Property Act, apart from the specific provisions of section 105 to somewhere around 117, there are additional terms of the Transfer of Property Act which apply. So if you look at some essential things, there is a transfer of an interest. So basically, in case of a lease, there is a transfer of interest. So a person who takes a lease, he takes a full possession along with the rights of enjoyment, a right to transfer, a right to sublet. So these are interests. So he, in a sense, gets into the interest, gets into the shoes of the lessor and accept the revisionary rights which the lessor retains. He kind of enjoys the property in full. There is a unconditional shift of possession. It's a transferable right which is inheritable. So a unique case, in case there is a demerger or a merger or an amalgamation order, the the resulting company steps into the shoes of the lessor. There is no requirement to do a fresh document. Probably under the agreement, you may be required to do atonement, but at the same time, it's automatic, which is automatically transferred to the second person. So if you see a lease, it's a right in rem, which is basically meaning that it's a right to enjoy the property against in respect of the world at large. It's not a right in personam, which is basically a right which is enjoyed against an individual. So as I said, it's a right in rem versus a right in personam. The rights of the lessee in case of a breach, it's not just confined to claim of damages for a breach of contract. It can go to the extent of filing for specific performance. If you look at rights of a licensor, lessor successor, it's something that the lessor steps into the shoes of the earlier seller who has been the earlier lessor. He automatically steps into the shoes. Now, a lease could be either express or implied. So express lease is something which you document, which is by way of a contract between the parties. Now, implication is something like, where there is no express contract, but probably a possession is granted by one person to another with the understanding that he would allow that person to use it and pay for it. So this kind of a transaction becomes an implied lease. Next is even where somebody is in possession for a very long duration and the rent is being accepted, it would amount to a implied lease. So we'll go to the next. So as we looked at the first, so there are possibly 2-3 kinds of usages which are material for us as mall owners. We would generally give the properties on lease, or we would give the properties on license. As mall owners, we don't want to get into a tenancy situation which is neither in the interest of the industry nor in the interest of us as landowners. So we would want something documented by which a right is of enjoyment or a right of usage is created in favor of somebody. So considering the inherent advantages which you have by virtue of a license, it's advisable that you consider a license as well for your properties. So as compared to a lease, which is a transfer of interest, a license is a very limited right by which a person permits another person to do something in respect of his property, which in the absence of such a right would have been unlawful, and it doesn't amount to an easement or a transfer of property. So we have seen a lease which is in the nature of a transfer of interest or a transfer of property. Now, second is they're saying it should not be a lease or it shouldn't be an easement. Now, easement, when you look at the easiest example of this is a right of way which you enjoy from somebody else's property by virtue of living closer to the property. So this, if you look at an easement, it's nothing but a right which you have in respect of somebody else's property for the beneficial use of your own property. So take a case that you are owning a property, and from the adjacent property you have a right of way. That would be the simplest example of an easement. So if you see, an easement is not something which you enjoy in respect of a property. It is something of a inherent accessory right which you get in respect of some additional property which helps you in the enjoyment of your own property, right? So when we look at an easement, when we now look at license, we need to see the critical elements. One, it's a grant to a definite person or a number of persons. It is a right to do or not to do certain things in respect of immobile property. essential element. It's a right which, if not given, would amount to a unlawful usage of the property. And lastly, it should not amount to a easement or an interest in property. So if you look at the essential elements, there are certain things like it's not transferable, it's something which you in case, say, there is a sale by the licensor to somebody else, the grantor's successor may not be required to comply with the terms of the license, and he can simply terminate it. In fact, this is a permission which is personal in nature, which is not transferable, not inheritable. So one is, of course, a document by which you do a license. There could even be certain implications by which a license is created. So take a case of a PG. When you give a PG, it's nothing but a simple license, if you call it. Or if you say permit somebody who is a friend to use your property for a certain remuneration, which is for a temporary usage, or say for a temporary term during which you feel that your property is vacant and your friend can occupy. So this would be some kind of a implied license, if you call it. Next, it can be invoked or revoked. It can be revoked at any time by the licensor, provided it's not coupled with interest. So next is on eviction. The licensee right is just confined to recovery of compensation. We just compare it now with a lease. Now, in case of a lease, in case you terminate, the lessor terminates, the right of the lessee is not confined to just recovery of damages. He can even sue for specific performance. Now, if you compare this with a license, a licensee cannot claim for specific performance. His right is just confined to, something like recovery of damages. Last, a simple comparison, the grantor is just bound to disclose defects which are likely to render or affect the usage of the property. Now, we'll more critically look at the difference between the lease and a license. So, if you look at some judgments which have happened over a period, so the courts have been very clear that the name of the nomenclature of the document doesn't really specify or doesn't really result in the court being able to identify as to the nature of the document or how the courts will interpret. The courts will interpret basis the conduct of the parties and the contents of the document as to what are the nature of the rights which are created, and then they will come to a conclusion whether it's a lease or a license. So, you may feel that by virtue of you signing a license agreement, you have done a license, or vice versa, when you have done a lease and you feel that you have done, something like a lease agreement, but if the contents of the document are such which do not fulfill the criteria of a lease and instead fulfill the criteria of a license, it would be interpreted by the court as a license. So be very cautious on when you're drafting a agreement, and also on the conduct when you are performing under the agreement. So now, if you look at distinguishing factors, one is if you look at the statutory basis on which a lease is arising, it's arising under the Transfer of Property Act, it's arising under the relevant provisions of the Rent Control Act. Of course, Contract Act applies everywhere, but as compared to this, now if you look at a license is arising under the Indian Easement Act. It's not arising under the Transfer of Property Act. Of course, the Rent Control Act at certain things applies, but generally the rent control doesn't apply, and that's the reason you do a license, so that the rent control doesn't apply. Now, nature of right which is created, this is a transfer of interest versus a license which is just a permissive use or a permission to use. In case of a lease, there is a transfer of possession. Now, if you look at a license, it's not really a transfer of possession. The possession remains with the lessee. the licensor, it's only a permission for the licensee to use the property. The juridical possession or the legal possession remains with the licensor. Then comes the difference of transfer or inheritance. So as we said, as we looked at earlier, in case of a lease, it's a transferable right versus a license which is not transferable. So typically, if you have given a license to a person and that person dies, the license comes to an end with the death of the person. Similarly, if you have given a license to a company and that company does a demerger or a merger pursuant to which the right gets, if the intent is that the right will get transferred to the resulting company, that doesn't happen, because as we said, a license is a right which is personal. It's not a transferable right. Now, if you look at right to defend possession, a lessee can defend the possession on his own. In fact, he can defend the possession even against the lessor. Now, if you look at similar thing with respect to a license, he will not be able to protect the possession. He will have to pursue any matter through the licensor. Termination and remedy in case of termination. So if there is a termination, as we discussed earlier, a lessee can go for specific performance, a licensee cannot. Foreclosure and sale. In case there is a foreclosure or sale, the lessor, where he has created, say, a mortgage, the bank would step into the shoes of the lessor automatically in case there is a foreclosure or sale, or in case there is a sale, the new buyer would step into the shoes of the lessor. Now, if you look at a license, in case there is a foreclosure or sale, it results in ending the license. It results in the license coming to an end. So this is something which is kind of differentiating a lease versus a license. We'll go to the next page. Now, knowing that there are these benefits which are arising from a license versus a lease, if the intent is that you want to give a license, you want to give a very limited rights, please be very careful. We just discussed that the conduct of the parties determines whether it's a license or it's a lease. So please ensure that you don't use words which are giving it a tonality of a license, of a lease. You need to avoid using words like demise premises, handover, rent, lease, tenancy. Very often you will see that you're writing mails which are coming from even from the best of landlords, where they are saying that your tenancy comes to an end. So you need to be very cautious, because the end of the day, it's basically the conduct of the parties and the document which determines whether it's a lease or a license. So you need to ensure that you don't put anything under the document which creates a right or which gives an indication that it's transferable. It's something like sublease can be created, or those nature of rights can be created, because the moment you give that tonality, it will be treated as a lease. Next, I'll get into the important aspect of stamp duty and registration. So if you see Schedule 1 of the Stamp Act, the Indian Stamp Act, similarly, if you see the other states have generally followed the Stamp Act as a model act, and thereafter modified their respective acts, so or prepared the acts on that basis. So a lease is something which is generally specified in Schedule 1, specifying the relevant stamp duty, and you will find that in I would say all the stamp acts. There would be no exception. The stamp duty which is payable is generally based on a percentage of the average annual rent. The percentage may differ, but then the basis is this. There are certain exceptional states which charge stamp duty on the basis of what is your whatever is your market value of the property. So, but if you take the example of, say, Rajasthan, any lease which goes, say, 10 years or something, you will have to pay stamp duty on that basis. Even at Maharashtra, if you look at, the stamp duty is based on the ready reckoner of value of the property. Now, if you so one thing which I can pinpoint specifically, which is a lacuna, in fact, which is being misused by the stamp authorities, is that currently there are various states which levy stamp duty even on the GST component of what is being charged on the lease rent. So if you look at, say, certain states, they don't charge, but say, take a look at UP. Uttar Pradesh specifically charges even stamp duty on the GST value of the rent or the CAM that is being charged. Now, as compared to this, if you look at a license agreement, so there are certain states, take the case of Maharashtra, take the case of Karnataka, Andhra Pradesh, Telangana, which specify and have an entry for license under the schedule. But however, if you look at other states, they may be most probably that the entry of a license in the schedule is missing. Now, being the case, if you approach a sub-registrar for paying stamp duty or for registration of the document, he will make you pay stamp duty on the basis of a license. So you may end up doing this, but be very clear that by virtue of registering the document as a lease, it doesn't change the lease. So it doesn't change the leave-in license to a license. So you can pay stamp duty, and that shouldn't be a basis of you dropping the intent that you want to do a leave-in license. Now, on registration, if you look at section 107 of the Transfer of Property Act, it provides that property which is required to be any lease that you create for a term exceeding 1 year, for a year-to-year basis, or which is reserving the annual rent, would require to be compulsorily registrable. Now, what is not registrable is something which is a oral lease which you create, or where you create a lease for a term which is less than 1 year. So the Registration Act, Section 18, creates an exemption for non-registration of a lease which is less than 1 year. But here I would like to caution you, though, like take the case of Maharashtra, though the the Registration Act specifies that a lease which is less than 1 year is not registrable, or license, typically the same would apply. However, the Rent Control Act in Maharashtra clearly specifies that all leases, licenses, irrespective of the tenure, have to be registered. So please be clear, check at the relevant state what is the applicability of registration, and please then apply. Now, as we discussed, there could be a month-to-month tenancy. Now, this is something which is done orally and may not require registration. So, looking at next point on consequences of failure to pay stamp duty and registration, immediate thing that you cannot enforce such a document. So, the next is, in case if you don't register a document, in that case, it would be treated like a monthly tenancy, wherein you will not be able to enforce the rights which you have created by virtue of a strong document. So be clear, you may create the strongest of the document, you may have all provisions covering every single eventuality. If you fail to register, if you fail to pay stamp duty, you will not be able to enforce it. So be clear on these things. So the only exception, as we saw, is something like a less than 11 months lease, or something which is a license, which would depend on the state laws, whether in certain states there is no provision for registration of a license, you can use those, but it's always advisable to register a document in respect of either a license or lease, because our stakes are very high. So I can take a short break. So if we have any questions, would be happy to take those. Sanjeev?
Yeah, in fact, it's great. It was a very interesting session. First part of your workshop is a very interesting, really very informative, very precisely. You have explained each and everything very minutely. In fact, a person, I'm not a person from the legal background, but definitely, if you allow me, I can explain certain things to the attendees. So I request all my attendees, if anything comes to your mind, any question, you just post it, and we will cover it. We will take your questions in the second break. So Vijay, what I would suggest, you just hydrate yourself, and let's start the second part.
Sure, give me a minute.
Yeah, please do that.
Sure. So we have so far discussed on the legal nuances in respect of a lease or a license or other kind of tenancy agreements. So now we would get into the nuances of drafting of the lease and license agreements. So to start with, as we discussed this provision for, so we discussed about the consequences of non-registration of agreement. Now we come to the next context, which is basically with respect to Section 108 of the Transfer of Property Act. Now, Section 108 clearly specifies that in case the agreement doesn't provide to the contrary, the provisions of Section 108 would apply in respect of a lease. Now, that being the case, you need to be very specific and deal with the relevant aspects of 108, the provisions which are captured there, so as to ensure that your document is is clearly specific on the issues and the provisions of your agreement apply, and you exclude the provisions of 108. Now, if you miss that, the provisions of 108 will apply, and you will be governed by the specific provisions therein. So, if you look at, say, 108, it provides for certain things which I will try to capture initially, and then I'll look at the balance aspects. First is responsibilities of the lessor. So the section clearly specifies that a lessor has to disclose material defects in property affecting the lessee use of property. Next, the lessee has to be put in possession of the property. He has to ensure that the lessee is able to use the property without any disturbance from the public at large, subject to, of course, his payment of rent and the requirement that the lessor has to carry out repairs. Now, these are things which are automatically coming out of the Transfer of Property Act. In case you fail to give details or deal with these issues, they will be governed by the Transfer of Property Act. Now, I'll go simultaneously for a license as well. So, a license as well, there is an obligation to disclose any defect which would affect the right of the lessee to use the property or which affects the property as such. If I compare the responsibility of disclosing provisions of title, etc., in respect of a lease, you would always prefer to be very specific and disclose everything, because in the absence of a disclosure, the lessee gets a right to terminate the agreement, or he gets various rights to claim damages, etc. So you would always want to disclose your defects in title. Now, as compared to this, if you look at a license, the requirement is very limited. You just need to ensure, or you can just simply say that the lessee licensor is sufficiently entitled to the premises, and disclose only something very specific which is going to affect the usage of the licensee. Now, take a case that you are fighting a suit with somebody in respect of title of the property, and at the same time you give the premises on lease or license, please disclose such a defect and be clear that the lessee or the licensee is taking the property with full knowledge of the case. Because if you don't disclose it and subsequently you were to lose the case, then apart from your loss of property, that's a separate thing, you will also be dealing with litigations with your licensee or lessor. So when I said material defects you have to disclose, there's also something like the Act expects that if there's something which a lessee should have known by his, in the normal circumstances, he's expected to know that. Next is, this is again under section 108, the lessee has a right to enjoy any accession in respect of the property. This could be something like if you have trees on the property, there are fruits, etc. That's something which will be to the benefit of the lessee. We'll go to the next page. So now, when you draft a agreement of a lease or a license, keep one thing in mind: you should deal with the rent control provisions of the relevant state and ensure that your property is outside the purview of the Rent Control Act. So if you have to build in provisions which ensure that you are kept out of the purview of the Rent Control Act, please add that to the extent possible. So something like, in Maharashtra, we see that common clause of paid up capital. That's nothing but just an attempt to ensure that in case by any chance the lessee is trying to make an effort to ensure that his property falls below the 1 crore capital and he were to claim tenancy or a protection as a statutory tenant, he shouldn't claim any, and the lease should terminate immediately prior to such happening of such an event. Similarly, other states have other specific nuances in respect of Rent Control Act. You have to ensure that you check the respective laws and ensure that your agreement is dealing with such aspects so that you don't be treated, or your agreement is not treated as a tenancy and the lessee doesn't claim protection under the respective Rent Control Acts. Reps and warranties, you need to ensure that you take warranties from the lessee or the licensor with respect to his, like simple things like, ensuring that he would keep the premises open for the full hours that you are open, something like brand usage, something like, usage of the property or ownership related. So nowadays, being in a mall environment, which is a controlled environment, you would want to ensure that the people or the tenants who are there, sorry, I am using the term tenant. So the lessee or the licensee who are there in your premises, they are not claiming, or they are people who you are comfortable with working, and you don't end up in a scenario that pursuant to a change of ownership, the respective people controlling the entity or the licensee entity become somebody who is not to your liking or who would create discomfort to you. So have provisions with respect to specifying who is the person in control, and taking a rep that in case there is a change, you will have a right to terminate. Take warranties in respect of capacity of the lessee to execute the agreement, and you would also at the same time be required to give reps with respect to your title and other things. Now, fit out is a common thing which I've seen is there's always a dispute between the lessor and lessee that what is the start of a lease or the period of fit out. So please be careful in drafting a fit out provision to say that when is the specific time that the fit out would start, because this is something which is always disputed by the other side. In our interest as lessors, as owners of shopping mall, we would want that the fit out period starts as early as possible, all the tenants occupy, and you are able to start the mall. At the same time, a lessee would look at a situation where others start their fit out. There are sufficient set of people who have already started their fit out and then only enters. So there's a constant tussle. Be very careful when you're drafting such a provision. Also have clear provisions with respect to how the fit out is to be done. So you can have manuals, you can have provisions with respect to sanction of drawings, the kind of material to be used, restrictions with respect to the look and feel, the colors to be used, your permission to be taken, so that you maintain the ambience and other things with respect to the premises. Repair and maintenance, I missed compliance with statutory building norms. Again, an important provision, because you are in a controlled environment. You have 150, 160 people who are operating under the single umbrella of a shopping mall. If you are, you don't want to be at a situation where, because somebody has acted in a difficult way, he has done some nuisance, and your entire mall is jeopardized. Specifically, say, take the case of food court units. If one of them were to, say, do something which is not in conformity with the statutory norms, and an accident would occur, the entire mall is at jeopardy. So please be very careful when you're drafting such provisions. Repair and maintenance. So as we saw, this is a provision of section 108. So when you look at this provision, the Act says that in case the lessor fails to carry out the repairs, the lessee can carry it out and deduct it from the cost. So you may be, feeling that you want to take certain cautions and then give a permission. However, if you are not careful in drafting the repair and maintenance clause to clearly specify who will carry out the repairs, what nature of repairs, you may be in a situation that you are at the receiving end, where the lessee carries out the repairs on his own and debits the charges to you, and then you are fighting. So be very careful when you're drafting such a provision. Now, looking at rent. So again, as we look at a shopping mall, this is a partnership between the lessee and lessor, and you want that each of them perform. So you would also get benefits by way of revenue share. So you would want to build in provisions which are very clear as to recovery, or as to the definition of net sales, ensuring that every single good which moves out of the premises, whether it's a e-commerce order, whether it's something like a WhatsApp or order on WhatsApp, or an order which is received at some other location but the delivery is done from your premises, you would want to ensure that the agreement is very clearly dealing with the provision and such an order is included in the net sales. Be clear with respect to receiving of daily sales, whether you have to install a ADSR or not. Similar things with respect to getting certified statements every quarter or whatever is your cycle of receiving rentals. Now, next is indemnity. So when you look at indemnity, you would want to have a provision to ensure that you are able to claim indemnity from the licensor and also from the lessee, and also at the same time disclaim your liability, because end of the day your presence is just to manage the premises. The people who are running the show is the lessee. You would want to ensure that there is no liability which passes on to you because there is an action by, say, some customer between lessees. So if one person does something in respect of his premises resulting in leakage in the lower premise, you would want to disclaim any such liability. So draw provisions with respect to clearly disclaiming liability. Now, on indemnity, when you're drafting an indemnity clause, just take I'll take indemnity as well as liquidated damages and penalty, all of them together. So if you look at the provisions, you may kind of draft provisions which provide for very high penalties, which provide for very high compensation. But when you look at from the perspective that how much is enforceable, you need to look at section 73, 74 and 75 of the Indian Contract Act. So when you look at 73, it clearly says that in case there is a breach of contract, you can recover loss or damages for the losses which are incurred in the normal course. So let's appreciate the difference. Here, what the Act permits you or what the court will permit you is to recover losses which would be recovered in the normal course. Now, it clearly excludes losses which are in the nature of indirect or consequential losses. Similarly, there is also a responsibility cast with respect to mitigation of losses. So in case you build in provisions with respect to lock-in, of course there are judgments on lock-in which may have some kind of different view, but please ensure that you have provisions which are reasonable. Now, if you build in provisions which are unreasonable, probably you will not be able to achieve your objective and your clause itself may be struck off. Section 74, which deals with liquidated damages or fixed penalties. So if you specify liquidated damages or penalties, what you will get is something which is reasonable and to the maximum extent of what you specify. And lastly, in case there is a person who is on the other side of the breach, the person who is the sufferer, he were to resign the contract for breach of contract, he is entitled to damages. So if you see all of it together, you need to ensure basically that your provisions with respect to liquidated damages or something like penalty, they are very reasonable. Say if you take a case wherein you say that if there is a delay in your payment of rentals, you will be entitled to recover 50% interest per annum. Be rest assured that such a clause will be struck off. Right? So whenever you are drafting such clauses, one, you need to take caution that you specify that these are reasonable damages. So though to some extent they may be unreasonable, specify that between the parties they understand that considering the circumstances of the case, this is something very reasonable and in the nature of liquidated damages. By virtue of doing this and at the same time ensuring that you put some reasonable damages, you will ensure that there is high chances of you being able to recover what you have specified in the agreement. Same time, certain things which you want as say to indicate that they are very penal in nature, probably you may not compromise, but considering what is permitted by the courts, just think over what you are putting under a liquidated damages clause or a penalty clause. We next go to force majeure of frustration. So if you look at the Contract Act or the Transfer of Property Act, it deals with a scenario which would be basically damages which result in destruction of the property, and it clearly specified in case such a situation were to occur, this would result in the agreement being voidable. Now, if you look at frustration, which is I think so section 56 of the Contract Act, so that specifies that in case the objective, you would say if you were to enter into an agreement and after the entry into of the agreement, the objective of the agreement becomes unlawful or the performance of the agreement becomes unlawful or something which cannot be done at that given stage, the agreement is voidable. So if you see what law provides is only a destruction of premises, in which scenario they say that the lease can come to an end. Second is if the objective of the agreement or the purpose for which the agreement was entered into at the time of signing, which was clearly legal, and at a subsequent date it becomes unlawful in something which comes from contractual agreements. So when you're drafting force majeure provisions, be very clear that there is nothing under law to cover it. It's more of covered as a subject under your agreement. So when you're drafting it, be clear that or you would want to confine it to damages to the premises which would result in the premises not being usable. You would, as a lessor or as a owner, want that the rent continues irrespective of the premises being say not usable for a day or two or for a certain period, because obviously your interest doesn't stop. So you would want a similar obligation on the part of the lessee or the licensee to continue to pay rental, because take a similar case, their bank interest doesn't stop, their obligation to take a something like pay the employees doesn't stop, and at the same time it's not a case that the premises have been returned to you for that date and you can use alternatively. The premises continue to be with the person, with the lessee. So you should draft your agreement such that such situations you don't disclaim your right to recover or recover rentals or other things. You should try to avoid, but it's a end of the day a contractual provision, so it would be between the parties to agree. But I'm trying to just build the arguments which you can use for this purpose. We discussed on liquidated damages and penalty. Now next is assignment. I'll take it along with sublease and mortgage. So again, getting back to section 108 of the Transfer of Property Act, in case your lease doesn't specifically cover this subject, these are permitted rights which are available to a lessee. So if you're silent on these things, a lessee may be able to assign his rights under agreement. He would be able to sublease. He would be able to create, third-party rights. Of course, within the duration, he'll be able to mortgage it. So you would want that there are clear provisions in your agreement which cover the subject. Now, you would want to ensure that you prohibit a sublease, or you want to clearly say that these premises cannot be mortgaged, they cannot be assigned. Clearly deal with them. Now, as compared to this, under a license, these are not rights which can be created. Again, as we discussed, license is a specific creation under the Indian Easement Act, which is personal in nature, not transferable. So obviously, if such things are there, it would change the nature of the color of the document. The document may be treated as a lease. So please be careful when you are drafting a license. You should ensure that even if you are silent, be very clear that these things are not specifically captured. That should be fine. But ensure some things like you don't provide that the licensee includes the successors or successors in title, because by virtue of this, you are indicating as if it's a transferable right. So deal with this aspect. Be clear that when you're drafting a license clause, don't cover the legal representatives or the successors of the licensee. You should confine yourselves to the specific person and specify under the agreement that this is a non-transferable, non-inheritable right. Next, on extension and renewal. So when you're drafting your agreements, if you are not cautious in defining whether what you are permitting is an extension or renewal, you may end up in a situation which is not to your liking. Say, take the case of where you want to say that it's a renewal, and you draft a language to say that this is an extension which can be extended for 5 years at the option of the licensee. If you put such a provision, a mere letter from the licensee saying that he wants to extend, it's something which would create the right to extend. He doesn't need to do a fresh agreement. That's why you need to differentiate between an extension and a renewal and capture it accordingly. A renewal is something which is clearly requiring a new agreement to be executed after the expiry of the agreement. So be careful in drafting it. On arbitration, so there were some judgments from the Supreme Court which had created, and from the lower courts which had created ambiguity on whether disputes under a lease or a license, they are arbitrable or not. So I think so this recent judgment of, not recent, it's I think so 2019 judgment of Durolia judgment, I'm missing the first name. Vidya Durolia judgment. So that judgment clearly specifies that in case the statute in respect of a contract which is governing the contract is something which clearly specifies that this is an issue which would be only be adjudicated by a specific court, or by way of prohibition says that this is not something which can be decided by in the ordinary courts by a civil court. Only those kind of things are some things which can't go for arbitration. So given our case, if there is a specific law which, or the Rent Control Act, or a specific law, something like a Presidency Small Causes Court Act, which says that disputes in the nature of recovery of possession under a tenancy agreement or a lease and a license can only be decided by the Small Causes Court in Bombay, then those disputes will go to the Small Causes Court and they cannot be arbitrated upon. Certain general clauses like non-waiver and severability or partial invalidity, they are critical because non-waiver would mean that in case you are waiving of certain rights and they are not recorded, they would amount to a non-waiver. Severability and partial invalidity is important because nowadays the extent of drafting when we do, we end up in a situation that we put in provisions which are to some extent not enforceable. So when you're drafting, please be cautious in drafting provisions and adding provisions which are adding the provision for severability and partial invalidity, because then you are protecting the balance provisions and ensuring that in case there is an ambiguity or your clause is not enforceable, you bring in provisions to say that it will be interpreted in the best way to enforce the document. Next, which is the last thing, I think so I've got a bit delayed, but I'll just cover this fast. So termination and consequences. So if you see section 1, C111 of the Transfer of Property Act, it says on expiry, so it says only the provisions or only the cases when you can terminate an agreement. So section 111 covers those things, which could be something like expiry, which is termination pursuant to a breach and other things. So that's a very general list. Now you need to be very cautious and cover provisions under the Rent Control Act, because then again you would don't want to fall under that gap. So you would want a right of termination also to be created in respect of an insolvency scenario, or there's a breach of any smallest of things, you would want to build in provisions with respect to termination, or nowadays SAFAC or winding up or anything, you would want these to be built in as a part of the agreement, because if you fail to add those, then again, as I said, you'd be governed by the Transfer of Property Act, and these rights will not be available to you. So at a given situation where you want to terminate a agreement, you may not be able to do so if you so want. Next is waiver of termination, which is basically section 113. So if you were to say, after giving a termination notice, you were to act such that you continue to accept rent without clearly specifying that this is accepted without prejudice, in that scenario, your termination is kind of waived. So cover that aspect by way of conduct as well as under the agreement, saying that any acceptance of rent after the termination would amount to it would be taken towards liquidated damages. Next is consequences. So please specify under the agreement that what are the post-termination obligations, basically vacating the unit, in case there is an overstay, what is the likely penalty, etc. Now, holding over is the last. Now, if you look at, basically, you need to have a specific provision which deals with the aspect that what happens if a person were to overstay beyond the agreed term of lease or license. Clearly specify that such a situation would amount to a holding over period. Specify the penalties or the liquidated damages which are payable in case of overstay. Additionally, please ensure that your provisions with respect to holding over, they are in sync with the rent control agreement, or you have clearly taken care of the rent control provision as not to apply to you. So if you fix up damages, consider rent control, consider section 73, 74, 75 of the Transfer of Property Act, because that would apply. I think so I have covered everything. So sorry to have extended this a bit. So happy to take any questions if there are any.
Yeah, Vijay, it was very interesting. Definitely, we have got some questions. It will not be possible for me to take all questions due to time constraint, but yes, we are taking few questions. Anshika Sharma, she is asking, what are the options available for term sheet of tenure less than 1 year? Should I repeat the question?
No, I understood. So, see, my take here is, if you're doing a term sheet, ideally that's not the legal solution to it, because if you look at, say, sharing of immovable property, it would either amount to something like a tenancy, or in case you're doing a term sheet which is not stamped and duly, say, stamp duty is not paid, you get into the ambit of that being treated as a tenancy, which is not the ideal scenario. So I have a suggestion here. Whenever you are doing such documents, try to see if they can be treated as term sheets for movable property. So you can create a platform and then give, say, those platforms on say 11 months term, which would ensure that you can always say that this is a lease or this is a term sheet for movable property, which is not covered under the Rent Control Act or under the Lease or Transfer of Property Act. I hope I have answered this to your satisfaction.
Nitesh Shetty, he is asking, let me know if online indemnity bond paper can be printed on A4 within the brackets color print, or it has to be on a bond paper only.
So I'm not clear, because nowadays there is this. There are these bodies which are like I think so, Stock Holding Corporation of India, which issue stamp papers which are online. So if you are referring to those and printing something on those, it's perfectly legal. So I think so that was what you were expecting as an answer.
See, Aman Sethi is asking, we have seen leave and license agreements being broken down into 5 years plus 4 years instead of doing a 9-year agreement. What is the thought behind this? What are the benefits or pitfalls, if any?
So I'll tell you, the genesis of this is basically the Stamp Act, or the Maharashtra Stamp Act, which if you remember, this is not something now. This is 20 years, 30 years back. when they initially permitted a license, and they said the stamp duty of license is very low. See, till date, if you see, the stamp duty of a license for a period is only prescribed for a period of 5 years. So that's something which people have taken for a gospel, and then that has continued. So there's nothing under the either under the Easement Act or the Transfer of Property Act which prohibits you from doing a 9-year lease. And also take note of the point that when you do a 5 plus 4 year agreement and do that 4 years by way of a side letter, that side letter is something which is not really a proper instrument. There's always a question mark on the enforcement of that side letter, because end of the day it's not stamped. Yeah.
Aman Sethi has posted one more question, and the question is: a lease agreement is generally done for a multiplex in a mall. Is this advisable? Are there any other instances where a lease agreement is executed?
So, I don't think so that's a right example that a lease is done for mall alone, because I would have come across malls which are completely on lease model. So every single unit, 120, 130, they're all on leases. So it's the discretion between the contracting parties to decide whether they want to do a lease or they want to do a license. So this could have been a particular case wherein the operator of the cinema would have insisted that I will only do a lease, then only I'll come in. That's why the developer would have come into and accepted this. And for other premises, he has been able to convince others to only do a license.
M. Rajashekhar, he is asking, is registered lease deed is required to be deregistered or cancelled when the tenant terminates the agreement?
So, the issue here is when you register a lease, it amounts to an encumbrance on the property. Now, having registered a lease which is for a specified duration, that encumbrance will remain on your property till the duration of the lease. So it's highly advisable that you cancel or register a cancel deed, because then by virtue of that you are taking care of the encumbrance and you are getting it removed from the property card or the papers in respect of the property, or this will continue to appear as an encumbrance on your property. So it's highly advisable that you do that.
Anshika Sharma is asking, does the indemnity apply in case of negligence?
Yes, it does.
Okay.
So any kind of indemnity can be for all kinds of things. You can take an indemnity for even an act which is not negligent, or you can say that you can even disclaim liability for negligence. But to tell you, basically, if you are silent on things with respect to negligence, there is an implied indemnity, because negligence that causes loss or damage to another person is protected under law and can claim indemnity from you even under law if it's not provided under the contract.
Vijay Ravi Kumar is asking, in reference to mall scenario, can a license agreement contains performance clause and not achieving might lead to termination?
So this leases and licenses are something which you are doing as contractual agreements for basically ensuring better performance of the mall. So having such clauses is something very normal and I would say enforceable also, because you have created rights and obligations on both sides. You have agreed to have a person because of some assurance of performance, and in case of failure you would want him to vacate and somebody else to come. That's something which is clearly fine.
In case of revenue share arrangement mentioned in agreement, how can we practically enforce sharing of sales / revenue data from retailers, as most are reluctant in sharing?
So this is a contractual provision. So if you provide under contract that he has to share, he is bound to share. So he may, all said and done, whatever reluctance, as long as he is signed, he will pay. I hope I have answered this. So this is completely a contractual provision.
Yeah. Suman Mondal is asking, what is the lease commencement date under lease agreement?
It's for your contract to specify. So this is more of, so I think so. I'm not clear on the question.
Yeah. Harsh Sharma is asking, if CAM is expense, then should we include in stamp duty calculation in UP?
Sorry, the last point was in UB.
Yeah, in Uttar Pradesh.
So I think so. UP is recovering stamp duty on CAM charges very clearly. So it is something which they are recovering even on CAM charges. Yeah.
Okay. Reshma Ravindran. Question is, if both arbitration clause and a jurisdiction clause is there, will a party of the agreement be able to file an original suit?
No, you can't. If you have a provision for arbitration, you have to go to arbitration. For in case only when you say lose or win, you can go for an appeal in the respective court. But you have to go for arbitration. Of course, for interim measures, you can go to the court.
Our question is, may I know the difference between lease or leave and license agreement in detail?
Okay, so I think so I captured it as a part of the presentation.
Yeah, it was there.
Yeah, so it's basically, the larger difference here is a lease is a transfer of an interest in property versus license, which is just a right to use. Then there are differences on transferability, usage, etc. I think so it's largely otherwise covered in the presentation.
See, this is the last question I'm taking because I'm getting a lot of questions from our viewers. But due to time constraint, it's not possible for us to take up all the questions. Now, there is a question from Anshika Sharma. This is the second question. Is letter of intent is a valid document before registration of lease? And if not, what is the valid document other than that?
See, I think so. A letter of intent to some extent can be treated as an agreement to lease. So, if you have appropriately drafted a letter of agreement and brought in provisions to clearly indicate that this is an agreement to lease, it's an enforceable agreement. Or you can follow that letter of intent with a agreement to lease, and that can also be an enforceable document.
Vijay, this is the last question from Rahul Saurabh. Some sub-registrar calculate the GST on rent in stamp duty calculation. Is it duplication of tax duty?
So I think so. The industry feels the same, that this is duplication of stamp duty. In fact, I covered this also in my presentation. So I think so. Since it's a state subject, people have been reluctant to go to the government, but this is definitely, to my understanding, duplication of taxes, and I think so. Whether SCAI or some other association should take it up. I'm adding work for you, Anjeev.
Thank you. So, Vijay, it was really a very interesting and enlightening session. I thank you for sparing your precious and valuable time for the Shopping Center Association of India and all its members. So with this, we conclude our today's session. Once again, I thank you, Vijay. Thank you.
Thanks a lot. Thank you.
To my viewers. Thank you.
Bye-bye.
That's it.